agency questions merge directly with tort law principles, especially negligence. We have to start with vicarious liability, which is most famously captured by the doctrine of respondent superior.
Let the master answer.
Exactly. It literally means let the master answer for the wrongs of the servant. It's the legal system saying, fundamentally, the boss is responsible for their workers' screw-ups if they happened while the worker was on the job.
Yeah.
Under this doctrine, a principal, specifically an employer, is vicariously liable, meaning liable without personal fault, to a third party who is harmed by an agent who's an employee and was acting within the scope of employment at the time of the harmful conduct.
Okay, so two key elements there, employee status and scope of employment.
Precisely. To hold an employer vicariously liable under respondent superior, you must establish both things. First, that the principal had sufficient control over the agent's conduct such that there was a genuine employer-employee relationship. Remember our earlier discussion, high level of control over the manner of work, not just the end result. This generally excludes independent contractors. Second, the employee's harmful conduct must have been committed while they were working within the scope of employment. This generally means the employee was performing work assigned by the employer or engaging in a course of conduct subject to the employer's control at the time the tort occurred. Was it part of their job or something closely related to it? This brings us right back to the independent contractor distinction, because independent contractors are not considered employees. Remember, the principal doesn't control the manner of their work. The general rule is that a principal is not vicariously liable for an independent contractor's torts. This is a huge incentive for businesses to classify workers as independent contractors, as it significantly limits their exposure to liability for the contractor's negligence or other wrongful acts.
But you said general rule. Are there exceptions? Times when the principal is on the hook for an independent contractor's torts?
Yes, and these exceptions are critical to know, especially for exams, because they often turn the analysis around. A principal can be held liable for an independent contractor's torts in several situations. First, if the principal retained control over the specific aspect of the work that resulted in the tort. For example, if a property owner hires an independent contractor painter but insists they use a specific rickety ladder provided by the owner and the ladder collapses, injuring someone, the owner might be liable because they controlled the dangerous instrumentality. Second, if the principal hired the independent contractor to perform non-delegable duties. These are duties considered so important, often related to public safety, that the law says the principal cannot escape responsibility by simply hiring someone else to do them. Examples include a business owner's duty to keep their premises reasonably safe for customers, or duties related to inherently dangerous activities like using explosives or fumigating. The responsibility stays with the principal.
Okay, retain control, non-delegable duties, any others?
Yes. Third, sometimes an independent contractor might act with apparent authority, and a third party relies on that appearance. If the tort arises from that reliance, maybe a fraudulent misrepresentation made by someone who appeared to be an agent, the principal could be liable. This is less common for torts than contracts, but possible. And fourth, perhaps most importantly, if the principal was negligent in selecting, training, or supervising the independent contractor. This isn't vicarious liability, this is direct liability for the principal's own carelessness. If you hire an independent contractor driver without checking their driving record, and they have a history of recklessness, and then they cause an accident, you might be liable for your negligence in hiring them. Now let's define that phrase scope of employment a bit more precisely, as it's often the battleground in these vicarious liability cases. We often talk about the distinction between a frolic and a detour.
Right, the delivery driver example. Yeah.
Exactly. An employee's personal errand or activity that involves a significant deviation from their work tasks or assigned route, both in terms of time and geography, is generally considered a frolic. It's outside the scope of employment. So if that delivery driver, instead of making their next delivery, decides to drive 50 miles out of the way to visit a casino for a couple of hours, that's almost certainly a frolic. The employer typically wouldn't be liable for an accident during that personal mission. However, if the personal errand involves only a minor deviation from the assigned work or path, a small departure, a quick stop, it's often considered a detour and generally remains within the scope of employment. Think of the delivery driver quickly stopping for coffee along their route or pulling over for a minute to answer a brief personal call. That's likely a detour. The employer would probably still be vicariously liable if an accident occurred during that brief stop. The line between frolic and detour can be blurry, very fact-dependent. Work-related travel also has specific rules that often come up. Commuting to and from the regular workplace is generally considered outside the scope of employment. That's usually seen as the employee's personal time and responsibility. But travel between job sites during the workday, or travel to perform a specific errand for the employer, or sometimes even travel home from a remote work site might be considered within the scope, depending on the circumstances and control factors.
Okay, that covers negligence mostly. What about intentional torts? Things like assault, battery, fraud. Is the employer liable then? That seems different.
It is different, and the general rule is that intentional torts committed by an employee are outside the scope of employment. Why? Because they are typically seen as being motivated by the employee's personal malice, anger, or self-interest, rather than serving the employer's goals. However, there are critical exceptions where an employer can be held vicariously liable for an employee's intentional tort. This happens if the conduct occurred within the general space and time limits of the employment, and the employee was motivated, at least in part, by a purpose to serve the employer, even if that purpose was misguided or the action was ill-conceived, or the act was the kind of act that the employee was hired to perform, even if they performed it tortiously.
Can you give an example of that last one?
Sure. Think of a nightclub bouncer, hired to maintain order and remove disruptive patrons. If the bouncer uses excessive force, commits a battery while removing someone, the employer might still be liable. Why? Because removing patrons is the kind of act they were hired to perform. The tort occurred during the execution of their job duties, even if done improperly. The courts often look at whether the employee's act was foreseeable in light of the nature of their employment. Was this kind of misconduct, sadly, a predictable risk of this job? Now, beyond vicarious liability where the employer is liable for the employee's acts, remember the principal can also have direct liability to third parties. This isn't respondent superior. This is the principal being liable because of their own fault or actions, not just because of the agency relationship.
Okay, how does that happen?
A principal is directly liable if they authorized the agent's tortious conduct or intended its consequences, or if they ratified the tortious act after the fact, though ratification of torts is rarer and more complex. Basically, the principal approved or directed the wrongful act. Second, and very commonly tested, if the principal was negligent in selecting, training, supervising, or otherwise controlling the agent. This is the negligent hiring supervision argument we mentioned with independent contractors, but it applies equally, if not more so, to employees. If an employer knows an employee has violent tendencies, but puts them in a customer-facing role without safeguards, and they assault someone, the employer could be directly liable for their own negligence. And third, if the principal delegated the performance of a non-delegable duty to the agent, and the agent failed to perform it properly, causing harm. Particularly duties involving inherently dangerous activities. The principal can't escape liability by just handing off inherently risky tasks that are ultimately their responsibility. Okay, that covers the principal's liability quite a bit. But what about the agent's own liability? We hinted at this. Do they get off scot-free just because they were acting for someone else?
I'm guessing no.
Definitely not. Let's look at their liability in contract first. An agent's personal liability as a party to a contract they negotiate depends heavily on how the principal was identified or not identified to the third party. This is a critical distinction to remember when figuring out who the third party can actually sue. First scenario, a disclosed principal. This is when the third party knows two things. One, that the agent is acting for a principal, and two, the identity of that principal. For example, if you hire a well-known architect, Sarah, to design your house, and Sarah tells the contractor, I'm representing John Smith, the owner, and he wants these specific materials, then John Smith is the disclosed principal. In this scenario, the agent, Sarah, is generally not personally liable on the contract. The contract is considered to be solely between the principal, John Smith, and the third party, the contractor, unless Sarah specifically agrees to also be liable. Second scenario, a partially disclosed principal, sometimes called an unidentified principal. Here, the third party knows the agent is acting for a principal, but they don't know the principal's identity. For example, a real estate agent might tell a seller, I'm making an offer on behalf of my client, but they don't reveal who the client is, maybe to keep the negotiations impersonal. The seller knows a principal exists, but not who. In this case, the agent is considered a party to the contract, along with the principal, unless they agree otherwise. The thinking is the third party is relying partly on the agent's reputation or credit, since they don't know who the ultimate principal is. So the third party can sue the agent directly. Third scenario, an undisclosed principal. This is where the third party has no notice that the agent is acting for a principal at all. The third party believes they are dealing solely and directly with the person in front of them. the agent. For instance, if I, acting as an agent for a wealthy art collector, go to a gallery and buy a painting without mentioning I'm buying it for someone else, the gallery owner thinks I am the buyer. In this scenario, the agent is a party to the contract. The third party can sue the agent directly. Later, if the third party discovers the existence of the principal, they generally can choose to hold either the agent or the principal liable, though often not both, to full recovery. And remember the crucial link back to authority. Disclosed and partially disclosed principals only become parties to the contract if the agent had actual or apparent authority to bind them, or if the principal ratified the contract. If the agent acted without any authority, the principal isn't bound, and the agent might instead be liable to the third party for breaching an implied warranty of authority, basically, for falsely implying they had the power to make the deal. Okay, that's contract liability for the agent. What about tort liability?
This seems more straightforward, maybe.
It generally is. The rule is clear and almost always applicable. The agent is always personally liable to a third party for their own negligent conduct and their own intentional torts. You simply can't escape responsibility for your own wrongful actions just because you happen to be doing them while acting as an agent for someone else. If you, the delivery driver agent, negligently cause a car accident while delivering pizzas for your employer, the principal, you, the driver, are personally liable for the damages you caused. The fact that your employer might also be vicariously liable doesn't shield you. You both might be sued. However, an agent is generally not liable for the principal's torts unless the agent somehow participated in or directed them. The liability typically flows from the agent's actions up to the principal vicariously, not the other way around. All right, so we've mapped out how agency relationships are formed and a pretty extensive landscape of liabilities that can arise with third parties. Now let's turn inward and look at the internal dynamics, the rights and duties of the parties to each other within that agency relationship. This is really about what the principal owes the agent, and critically, what the agent owes the principal. It forms a reciprocal relationship, often centered around what we call fiduciary duties. Let's start with the principal's rights and duties. What can the principal expect, and what must they provide? On the right side, the principal generally has the right to control the agent's actions within the scope of the agency, especially regarding the ultimate objectives. They also have a right to receive timely notice and a proper accounting from the agent. This means the agent must keep the principal informed of all relevant information they learn and provide clear records of any money or property handled on the principal's behalf. And fundamentally, the principal has the right to expect the agent to deal fairly and in good faith throughout the relationship. It's built on trust. Correspondingly, the principal also has duties owed to the agent. These include the duty to compensate the agent for their services, assuming it wasn't agreed to be a free, gratuitous agency. They generally have a duty not to interfere unreasonably with the agent's work, allowing the agent to perform their delegated tasks effectively. And a crucial duty, especially if things go wrong, is the duty to indemnify the agent. This means the principal must cover any losses or liabilities the agent incurs, while acting properly within the scope of their actual authority, and for the principal's benefit. For example, if the agent gets sued on a contract they properly entered into for a disclosed principal, the principal generally has to cover the agent's legal fees and any judgment. They also usually have a duty to cooperate with the agent and provide a safe working environment, particularly for employees. Now, if the agent breaches their duties to the principal has several potential remedies for that breach. There's quite a list, but think of it as the principal having a whole toolkit of legal options. These can include seeking an injunction from a court to stop the agent's wrongful conduct, like preventing a former agent from using confidential information. They can pursue contract damages if the agent breached the terms of an agency agreement, e.g., the agent failed to perform the agreed-upon services diligently. Or they might seek tort damages if the agent's breach also constituted a tort, like negligence, fraud, or conversion of property. But one fascinating remedy, particularly relevant to breaches of loyalty, is disgorgement of profits. If your agent secretly profited from their disloyal act, like taking a bribe or using your resources for a side deal, you can potentially force them to hand over all those ill-gotten gains to you. Other remedies might include rescinding contracts tainted by the agent's breach, seeking restitution for any unjust enrichment the agent received, demanding a formal accounting to figure out what happened financially, and of course, the power to terminate the agency relationship itself, and sometimes even forfeit any compensation owed for the period of disloyalty.
Wow, that's a comprehensive list of what the principal can do if the agent messes up or, worse, betrays their trust. So, what about the flip side? What is the agent entitled to expect from the principal, and what are those core duties that an agent owes back to their principal? This is the employees or contractor side of the ledger, right?
Exactly. Let's look at the agent's rights and duties. For the agent's rights, they generally have a right to receive the agreed-upon compensation for their services, unless, again, it's a gratuitous agency. They have the right to perform their work without unreasonable interference by the principal. They also have rights to indemnification for liabilities incurred while acting properly and reimbursement for reasonable expenses they paid out of pocket while carrying out the principal's instructions, things like travel costs, supplies, etc. And particularly for employees, there's a right to work in a reasonably safe work environment.
Okay, those are the rights. Now, the duties, what's fascinating here is these feel like the absolute core of the relationship, the duties an agent owes to their principal. These seem incredibly important to remember when you're analyzing an agent's conduct, especially on something like the bar exam. These are the pillars of trust and responsibility.
Absolutely. These duties owed by the agent to the principal are paramount. They're often collectively referred to as fiduciary duties because they demand the highest levels of loyalty, trust, and good faith. They are central to agency law. Let's break down the key ones. First, the duty of care. An agent must act with a reasonable care, competence, and diligence that is normally exercised by agents in similar circumstances. Essentially, do your job carefully and professionally, up to the standard expected in that field. Don't be negligent in performing your duties. Second, the duty of obedience. The agent has a duty to obey all reasonable directions and lawful instructions given by the principal within the scope of the agency relationship. If the principal says, don't sign any contracts over $10,000 without my approval, the agent must obey that instruction. Now, this duty doesn't extend to instructions that are illegal or unethical, of course.
Makes sense. Care and obedience. What else?
Third, the duty to provide information, sometimes called the duty of notification. An agent has a duty to use reasonable efforts to keep the principal informed of all material facts related to the agency that the agent knows or should know, especially information that is relevant to the principal's interests or decisions. If the agent learns something important that could affect the principal's business or the transaction at hand, they have a duty to disclose it promptly. Communication is key. Fourth, the duty to keep and render accounts. The agent must keep accurate records of all money and property received or paid out on the principal's behalf. They must not commingle the principal's property or funds with their own, and they must provide a full accounting of these transactions to the principal upon reasonable request. This ensures transparency and prevents misappropriation. And perhaps the most critical, the cornerstone fiduciary duty, is the duty of loyalty. This is a broad and pervasive duty. It requires the agent to act solely and loyally for the principal's benefit in all matters connected with the agency relationship.
Undivided loyalty.
It's
Yeah.
exactly undivided allegiance. This duty includes several key prohibitions. The agent must avoid conflicts of interest. They generally cannot act for competing principals or represent both sides of a transaction without full disclosure and consent from both principals. They must not engage in self-dealing acting for their own benefit in a transaction connected to the agency at the principal's expense. They must not compete with the principal concerning the subject matter of the agency during the relationship. And they must protect the principal's confidential information both during and sometimes even after the agency ends. It demands that the agent put the principal's interests completely ahead of their own personal interests within the scope of the agency. This duty is why, for example, if your real estate agent secretly buys a property for themselves that they knew you were interested in and were supposed to be helping you acquire, it's a massive breach of the duty of loyalty. And just quickly, if the principal breaches their duties to the agent also has remedies. The agent's remedies for breach primarily include suing for contract damages if the principal breaches the agency agreement, for example, by failing to pay the agreed-upon compensation or failing to reimburse legitimate expenses. In some cases, they might also be able to pursue tort damages if the principal's breach constitutes a tort, like wrongful termination in violation of public policy, or perhaps defamation related to the agency.
Wow. Okay, this has been an incredibly thorough deep dive into agency law. It's definitely a lot of information, incredibly detailed, but you've laid it out so clearly. So let's bring it all together. What does this all mean when you, our listener, are faced with an agency question on a test, especially for someone preparing for the bar exam where these issues love to intertwine with partnerships, corporations, or torts? How do you systematically approach breaking down a fact pattern?
That's the million-dollar question, isn't it? How do you take all this theory and apply it methodically under pressure? Because the bar exam absolutely loves testing agency principles, often weaving them into questions about business associations or torts.
So here's a structured 5-step approach. Think of it as your blueprint for analyzing agency fact patterns. If you follow these steps consistently, you'll ensure you cover the key issues logically and maximize your points. Step 1. Identify the agency relationship. Always, always, always start here. This is your absolute first move. Don't jump to liability yet. Look for those ABCs. Assent, benefit, and control. Is there evidence that both parties manifested consent to this arrangement? Is the purported agent acting primarily for the principal's benefit? And crucially, does the principal have the right to control the agent, either the result or the manner if you suspect an employee relationship? Clearly state who you think the principal is and who the agent is. And very importantly, determine what kind of agent they are, likely employee or independent contractor, as that dictates liability rules later. If you conclude an agency relationship doesn't exist, explain why, based on the ABCs, and much of the subsequent analysis might be unnecessary. If it does exist, state it clearly and briefly explain why, referencing those ABC elements in the facts. Step 2. Determine whether the agency relationship or the agent's authority has terminated. This is particularly crucial for contract liability questions, and it's often a hidden issue or trap on exams. Ask, did something happen to end the actual authority? Was there a revocation by the principal? A renunciation by the agent? Did the terms of their agreement expire? Did significant change circumstances occur? Did the principal or agent die? If actual authority is terminated, your analysis isn't over. You then must assess if apparent authority still exists. Did the third party still reasonably believe the agent had authority based on past principal actions? Or if the principal subsequently ratified the unauthorized act? Always check this termination timeline before concluding the principal isn't bound. Step 3. Discuss the liability of the principal for the agent's actions. This is usually the heart of the problem. The big is the principal on the hook question. You need to address this differently for contracts versus torts. If the issue involves a contract the agent entered into, methodically analyze actual authority. Was it expressed or implied? Remember, focus on the agent's reasonable belief based on principal-to-agent communication. Then analyze apparent authority. Did the third party reasonably believe the agent had authority based on the principal's manifestations to them? Finally, check for ratification. Did the principal, with knowledge, affirm the unauthorized contract later? Discuss each potential basis for liability. If the issue involves a tort committed by the agent, start with vicarious liability under respondent superior. Ask, was there an employer-employee relationship? Look for control over manner. If yes, was the tort committed within the scope of employment? Apply frolic versus detour rules. Consider travel rules. Analyze the exceptions for intentional torts. If it was an independent contractor, vicarious liability generally doesn't apply, unless one of the exceptions kicks in. Retain control, non-delegable duty, apparent authority, negligent hiring, though negligent hiring is technically direct liability. Then also consider direct liability of the principal for the tort. Was the principal themselves negligent in hiring, training, or supervising? Did they authorize or ratify the tort? Did it involve a non-delegable duty? Cover both vicarious and direct routes to principal liability in tort. Step 4. Address any potential liability of the agent themselves to the third party. Don't forget the agent. This involves two main possibilities. For contract liability, analyze whether the principal was disclosed, partially disclosed, or undisclosed to the third party. This determination dictates whether the agent is personally liable on the contract. Also consider if the agent might be liable for breaching the implied warranty of authority if they acted without power. For tort liability, remember the straightforward rule: the agent is always personally liable for their own torts, negligence, or intentional. Briefly state this clear rule. Step 5. Discuss any breach of fiduciary duties between the principal and agent. This covers the internal relationship. Analyze the key duties owed by the agent to the principal, primarily the duties of care, obedience, notification, information, accounting, and especially loyalty. Did the agent breach any of these based on the facts? If so, what remedies might the principal have? Damages, disgorgement, injunction, termination. Conversely, briefly consider if the principal breached any duties owed to the agent: compensation, indemnity, non-interference, safe workplace. What remedies might the agent have? Showing you understand this reciprocal nature demonstrates a complete grasp of the agency relationship. Following this systematic 5-step approach really helps ensure that you address all the relevant legal issues logically and comprehensively in your analysis. It maximizes clarity, covers the bases, and gives you a solid framework whether you're tackling a bar exam essay or analyzing a real-world agency problem. It's your roadmap.
Wow, that is a truly fantastic blueprint. Incredibly helpful for anyone needing to structure their thinking on these complex questions. This whole deep dive into agency has really, I think, peeled back the layers on how understanding these foundational principles can demystify what seems like a really core area of law. You can absolutely see how these agency relationships aren't just, dry legal constructs tucked away in textbooks. They are fundamental patterns woven into how individuals and organizations interact every single day, from the simplest favor for a friend to the biggest corporate merger. It really is pervasive.
It absolutely is. And that actually raises an important question for you, the listener, to maybe mull over after we finish. Considering just how subtly agency relationships can form sometimes, without anyone even using the word agent or principal, and considering the profound legal implications that can flow from them, both in contract and tort, how might this understanding change the way you approach your own everyday interactions? Whether that's at work, maybe when you're volunteering, or even just when you're assisting a friend or family member. When might you be unintentionally creating an agency relationship, either as a principal or an agent? And what might that mean legally down the road? It really encourages some critical thinking about those invisible but very real legal threads that connect people and their actions. Maybe think about the potential legal weight behind a simple yes next time someone asks you for help.